The question is that this bill be now read a second time. And I call the honourable member for the amazing seat of Indi.
Thank you, Mr Deputy Speaker. I rise to speak to the Australian Citizenship Amendment Allegiance to Australia Bill 2015 and explain to the House why I will not be supporting this bill. My opposition to the bill is not directed at the intent or purpose of the bill. It is focused very clearly at the inclusion of a retrospective provision and under the cloud of uncertainty on the constitutional viability of this bill. You can go to dinner. I know that the bill has been amended following recommendations from the Joint Committee on Intelligence and Security, and there have been a raft of necessary amendments. But it appears that even after the amendments have been made, the bill may be constitutionally vulnerable, and if this bill is so very important and critical to the health, safety and welfare of all Australians in the face of terrorism, it should be invincible. On the 24th of June this year, when the Minister introduced the bill into this House, he affirmed that he was implementing a commitment made by the government to address the challenges posed by dual citizens who betray Australia by participating in serious terrorism-related activities. The initial bill was roundly criticised by legal and constitutional experts. It raised significant questions relating to human rights, statelessness, citizenship and the limit of executive power. Many of these criticisms have now been addressed. My reasons for not supporting this bill differ markedly from the reasons I failed to support the tranche of national security bills previously presented by the government. In regard to earlier bills, when bills of such significance are considered necessary, it's imperative that everybody, individual organisations, communities, businesses, have adequate time to scrutinise and comment. The lack of independent scrutiny of earlier bills, combined with the lack of time given for members and senators to consider these complex bills, formed the basis for my non-support. The bill here today has taken a more considered and consultative pathway, and I commend the government for taking the time necessary to consult and listen before bringing this bill on for consideration by the House. And I note that the Joint Committee received more than 40 written submissions, conducted 3 public hearings with a broad range of legal groups, academics, non-government organisations and government agencies. The bill, as now amended, reflects that the government has listened and acted to a degree, and this is good. However, Madam Deputy Speaker, in this parliament we focus on the rule of law. Our processes and procedures work to ensure that we have the highest possible standards of government and best outcomes for the people of Australia. The integrity of the rule of law is critically important to me in my role as a lawmaker in this parliament. And the central element of the rule of law is that laws are capable of being known in advance, so that people subject to those laws can exercise choice and order their affairs accordingly. It follows that laws should not retrospectively change legal rights and obligations or create offences with retrospective application. Retrospective laws make the law less certain and reliable, and a person who makes a decision based on what the law is today will be disadvantaged if the law is changed retrospectively. And from my perspective, enacting a retrospective law weakens the rule of law and has the potential to lessen the level of confidence the people of Australia have in us as legislators. Professor Anne Toomey, a professor of constitutional law at the University of Sydney, notes that part of the bill most vulnerable to attack would be the retrospective provisions for people who had already been convicted of certain offences. I share Professor Toomey's concern on this issue. But in this case, Madam Deputy Speaker, it's not only the retrospective nature of legislation that worries me and my constituents. The bill blurs the line between executive power and judicial power, where the minister can, at a stroke of a pen, remove a person's citizenship. Constitutional lawyer Professor Toomey has said that the issue was whether removing a person's citizenship would be treated by the courts as something that is akin to punishment and therefore exclusively judicial in nature. And I note that the Shadow Attorney-General, in his speech on this bill in this place on the 12th of November, raised concerns with the constitutional viability of this bill. Ultimately, the opposition has chosen to accept the government's advice that it is constitutionally sound. Madam Deputy Speaker, citizenship brings with it rights and obligations. Clearly, it's not a one-way street. It provides us with the right to political participation in the life of the community, the right to vote, the right to receive certain protections at home and abroad. And this bill speaks to the very heart of our obligations as a citizen, obligations that we have, whether we are citizens by birth or by naturalisation. I know that many others have referred to the pledge to citizenship that is read out across Australia every week by new citizens and that we as members of parliament frequently accept. The pledge. From this time forward, I pledge my loyalty to Australia and its people, whose democratic beliefs I share, whose rights and liberties I respect, and whose laws I will uphold and obey. Whether we are citizens by birth or naturalisation, the pledge enshrines the rights and obligations that all Australians share. And for us here today, the scrutiny of our nation and our people is for us here today, the security of our nation and our people is paramount. And I fully support the government taking steps to introduce legislation to ensure the safety and security of Australians and its citizens. However, it must be good legislation. In closing, my opposition to this bill is not directed at the intent or purpose of the bill. It is focused very clearly at the inclusion of a retrospective provision and under the cloud of uncertainty on the constitutional viability of this bill. Thank you.